Good morning to everyone. My name is Nadejda Busuioc, chairperson of Panel F, and I declare this session open. The Prosecutor Vetting Commission was established and functions under Law number 252 of 2023 on the external evaluation of judges and prosecutors. Therefore, the law 252 establishes that this commission will undertake an ethical and financial evaluation of prosecutors who are identified in Article 3, Paragraph 1 of that law as subjects of the evaluation. This three-member panel is constituted to conduct the evaluation pursuant to Article 15 of Law number 252. I am joined by my colleagues on this panel, Ion Grauer, who is in the room, and Mrs. Laura Stefan through video conference. The panel is also assisted by members of its secretariat. This hearing is being conducted pursuant to Article 16 of that law, as well as the Commission's rules of procedure for evaluations under Law number 252. The subject of today's hearing is Madam Nadejda Busuioc, prosecutor in the Anti-Corruption Prosecutor's Office, subject of the evaluation according to Article 3, Paragraph 1, letter E of the Law 252 of 2023. Madam Busuioc, welcome to today's hearing. Thank you. Good to see you. This hearing is open to the public and members of the media, except part of it, which will be conducted in closed session following the request from the subject that was accepted by the panel. The hearing will be conducted with interpretation in Romanian and English. So we will speak in Romanian. All the members of the panel are Romanian speakers, but all discussions are being translated into English. So to allow for an accurate interpretation, please speak slowly and clearly. And according to Article 16, Paragraph 3 and 4 of the Law 252, the proceedings are being recorded. Audio and video recording. The recordings of this public hearing will be available on the Commission's official website within 3 days after the hearing. During the hearing, one or more members of the panel will ask questions to you. Please answer them truthfully and completely. Your explanations are important to us in verifying your compliance with the criteria for financial and ethical integrity. In formulating our questions, we will take into account your privacy and, where required and possible, the privacy of your family members and close persons. So we will leave out unnecessary details relating to ID numbers, bank account numbers, specific addresses of real estate, and the like. For the protection of your privacy, as well as your relatives, we ask that you do the same. By the end of this hearing, you will also be given the opportunity, Madam Busuioc, to make a closing statement to the panel. I will start by briefly reviewing the evaluation process for the subject. The Commission initiated the evaluation process on the 24th of May 2024 by notifying you by email and asking you to complete and return an ethics questionnaire and a financial declaration form for the recent 5 years as required by Law 252. You returned these documents on the 12th of June 2024. As part of evaluating the subject's ethical and financial integrity, the Commission also obtained information from many other sources, such as National Integrity Authority, State Fiscal Service, the General Inspectorate of Border Police, other public institutions, financial institutions, and open sources. The Commission assessed the information obtained from these resources for its relevance and reliability. The panel sent you 3 rounds of questions as of 8th of April 2026, 15th of May 2026, and 3rd of June 2026, to which you responded. As of 31st of July 2026, the panel notified you about today's hearing and informed you also that following the analysis of the information gathered, the panel has specific doubts that wants to be discussed with you during this hearing. The doubts were presented to you in the annex to the hearing notice that was sent to you. You confirmed as of 3rd of August your participation to the hearing and asked for access to the discovery file. And this was granted to you on the 5th of August 2026. Madame Busuioc, I want to mention that the panel also received your written position regarding the hearing notice and the annexes, given the short deadline from when the documents were sent, and the panel actually has not managed yet to look into all documents that you submitted. So we kindly ask you to keep into account that questions of today's hearing mostly rely on the doubts that were communicated to you on the 31st of July. Please be sure that all documents that you submitted to us will be reviewed till the report is issued. And if you believe that something should be underlined today from the documents that you presented later on, please be specific. I will start by asking 2 short clarification questions, and just sincere and short answer will be sufficient. Would you like to add or change some answers and information that you presented previously to the panel in the rounds of questions or in the documents that you presented? No, I don't have things to add to the documents I attached to the rounds of questions. But as you said, I came with a written position supplemented by the documents, and these are actually the things I wanted to add. And the answer that you presented, that you submitted to the rounds of questions, especially to the 2 documents as of 12th of June 2024, those are still valid as of today? Yes, I confirm. Thank you. I will just try to explain our today's approach. We will discuss the first item in the hearing notice that will be reviewed in public hearing. Then we will switch for closed session, and we'll close the full hearing. So I will give now the floor to Ion Grauer, who will ask the questions to the subject, please. Greetings once again. Madame Busuioc, let us start with the inexplicable wealth from 2012 till 2014. In the answers to the rounds of questions, you said that you lived in that period from 2012 till 2014 with your parents. And as a sitting judge in that period, you had higher incomes than the national average. How do you explain your position that you had lower income than those according to SEP? Well, I actually explained this in the round 2 and 3 of questions. I actually said there were no negative balances for 2012-2014, given that that balance was due to overestimating my expenditure, especially for the utilities and the food products. I want to repeat that during that period, I used to live with my parents in the same apartment. The food products for the entire family and the utilities related to living in that apartment were paid by my parents, because they were those that were managing that household and took over such expenditure from the moments we used to live together, from when I was in school actually. When I got a job, this habit never changed, and my parents never asked me to pay the utilities or to buy food products in order to provide for my family for these purposes. I also don't agree with the findings of the panel, according to which my parents had a lower income than I had in that period, like altogether accumulating the incomes from both parents. And my reasons are the following. Well, I suppose that the Secretary of the Commission did not include in the calculations for the financial flows of my parents the pension for job experience that was obtained for my parent as a former civil servant in the Ministry of Interior. This was indicated and explained in the round 3, question 4, and to support that, I came with an official confirmation certificate issued by National Social Insurance House by the letter 10433 of 2026, sorry. And that was sent to the Commission as of 24 of June 2026, 8:20 a.m. And it was confirmed to be received a bit later. The pension received by my stepfather as well as other allowances and facilities, social facilities received. And in 2012 till 2014, the income of my parents accumulate a higher amount. And in 2012, my parents had an income from the following legal sources. The pension of my father, 53,900, social allowances, and my father's salary, 28,000, my mother's salary, and total 133,549, and by reducing the CAP for 2 people of 552,000, we have a positive balance of 81,000 something, not as indicated by the Commission. In 2013, my parents had incomes from the following legal sources. The pension of my father, 56,846. Please, Madam Busuioc, you asked to have a closed session regarding your family's incomes. So now my question is, do you want indeed to give all these numbers in public hearing, or you trust that those were calculated correctly and you want just to explain your argument, saying that the incomes were not calculated correctly for 2012-2014 because they had enough income to cover fully the expenditure for consumption expenses for 3 people. So you understood correctly. So you have my calculations in the written explanation, written position that I submitted to you. So I kindly ask you to take into account that even though there are some small differences of 2, 3, 4 lei, let's say the current is not changed, meaning that a significant amount was left out from my parents' income, which actually affects their entire financial situation and affects the period after 2012 till 2014. One more question. You had some cash and the money on the card that was withdrawn from the card that seemed to cover the daily expenditure. And you said that some part of the withdrawn money was used for current expenses. Do you claim now that that answer was wrong or it was correct? By current expenses, I meant that I had to go to work and meanwhile maybe I needed a bottle of water or something else. That's what I meant, daily expenses. For example, in 2014, the panel identified 20,000, 135,000 for retail expenses from the Banca Economii. Is your position that you have not used that 8,000 lei difference between the retail identified and the CEP expenses? Well, I cannot say for sure that I spent no money for the food products. However, the difference for 2014, for that period that you said, is 12,000. In those 12,000, definitely we have utilities included and food products, because part of this difference is not covered by the CP, the consumption expenditure needed for the food products. So maybe I used my card for some retail expenditure in some shops or grocery stores, but those 12,000 difference for 2014, which according to the Commission were not in my possession, was covered by my parents because we were sharing the same household. The utilities, I'm sure, were paid by my parents. Okay. I just want to understand, what is your stance now? Have you spent money for the household? Any money or not at all? Because we have different categories according to CP. So what's your final position? All the expenses regarding the utilities were always paid by your parents? So do you want to exclude the utilities from the CP or what exactly? I asked in the rounds of questions to exclude the utilities fully from these calculations, and the food. When in the round of questions, I did not ask to exclude them fully because I had made some expenses incurred by me, but the difference that was established by the panel, 8,000 for 4,000 for 13 and 12,000 for 14 is not the full amount for the food products according to CP. The food products would make out about 34% of CP, right? So do you admit that at least 50% was spent by you for the CP? Well, I admit that maybe in 2014 I did spend 50%, but in 2012 and 2013 I do not admit I spent 50%, maybe 20 or 25% for these expenses, because that's the way our household was organized. I was able to buy something for my personal use at work or in the city. And didn't you used to buy something, some food to bring at home? Well, actually, my mother is the one that is cooking, and she's not asking to be paid for or to be bought products. Well, we agree they do not ask for that, but children do this from their own initiative. Well, dear Chairperson, I believe that the parents nowadays are making their best to help their children have the best living. I know my parents, they never wanted my life to be difficult. I was a young employee, I was in doctoral studies, and my parents did all their best to create living conditions the best for me. So your final stance is that you did not contribute at all to the expenses for the apartment utilities as well. And maximum 50% in 2014, you participated in buying food products. Well, thank you. No more questions for now in this sense. Now, let's go to the second question. The source for the apartment on H Street. Those were savings in cash. Your parents bought in 2018-19 an apartment on H Street by investment. contract. In your rounds of questions, you said that your parents bought that apartment in Chișinău using the following sources: cash savings, the money from the sale 1 month before by your mother of a flat inherited from your grandmother by an investment by this before this investment contract, and loans from third parties. Regarding the cash savings of your parents had a house of 188 square meters and a land of 3.25 acres till 2012. This contract seems to be purely formal because your stepfather made a contract from 2006 to build those two duplex houses, in exchange of which he was to receive one of these and half of that land. According to the contract in 2012, your parents had this property of about 700,000 lei. The agreement and the contract from 2006, the Handover Act from 2010 July, in which we refer to this contract in this contract in 2012, the contract from 2012, and the information of from the cadastral service. Can you clarify the major details according to which you and your mother managed to get this property? I can tell you that these are very complicated. I actually clarified them in the rounds 2 and 3 of questions. That element was not included in the hearing notice. There were no doubts regarding the way I purchased it or the right of ownership of myself and my mother. There were doubts in terms of the sources of money to pay for this apartment. And going back in time, in terms of the events, I want to say that in 2006, my father, in April, concluded an agreement with another person that had or owned a land plot. So that my father owned that land plot to build a duplex and to get in return half of that land plot and half of that house. I want to mention in this regard that on that land plot there was another construction which is indicated in the sales purchase contract, which has the final numbers 01. That dwelling of 178 square meters was built by my father in 2006-2007, and that was registered later on with the cadastral number that has last number 02. Based on the sale purchase contract of 2012, according to that amount of 699,175 lei, my parents received quotas or shares from 3 properties. 3/8 from the land plot on which that house with the number 02 was built, 3/8 from the living house of 110.3 square meters, having the final cadastral number 01 that existed already and which was a historical house and later on was demolished given its poor technical condition, which is also said about in the round 2 of question, and the share of the house that has the number 02 in the end that belonged to my parents. And this amount of 699,175 that was seen by the Commission as an investment because the contract was a benchmark for the Commission to calculate this value of the investment. Well, this is not the value of the construction for that dwelling having the number 02 in the end. This amount is the cadastral value of the entire real estate, the property that is registered with the cadastral. The land, shares of the land plot, and shares from the two constructions on that land. The cadastral value, I repeat, according to that certificate issued by the cadastral state agency. And this value of about 700,000 is not in no way the investment made by my parents in this property. It can not be seen as the cost for three dwellings as an investment for just one property. And I believe that the land cost even more than the construction on that land plot that was bought from own sources, as I said in the rounds of questions and in my written position that I submitted to the Commission. Another remark: if we focus on the value of investments, because the value of investments influences significantly the financial flows of my parents for the evaluation period in 2006 till 2017, 2006-2007, before buying the flat. According to that agreement in 2006, it is said that the cost of investment for the part that remains with another owner is of $10,000. And given these ideas, the value of the investment for the quota of my from the property that was to belong to my parents of 89 square meters, because that's the part that my parents obtained as a result, can be seen as being worth 10,000 euro, even though this surface is smaller than the one that is with the other co-owner. So that one decided he would receive a construction worth $10,000, and my parents received another part worth 10,000 euros or dollars, even though the property is smaller. Another aspect is that the Commission sees the construction works as conducted before 2012. But as the agreement says, which was signed in 2006, the construction works were started in 2006. I produced to the Commission invoices and receipts of about 113,000 lei from 2006 till 2007, which amounts for $9,300 US, which confirms that in this period the most important investments in that construction were made. And these are only the in the documents that were kept by my mother, given the long time that passed from that moment. So I declared repeatedly that in 2008-2012 there were no massive constructions that would have needed significant investments. In 2014, there were some repair work when my parents moved in that property to occupy the part of that property that belonged to them. Going back to explaining the calendar of events, in 2012, the right of ownership was registered in the name of my parents when it came to the shares that they were entitled to receive according to that agreement. And the fact that those property rights were only given to them only in 2012 is not due to the fact that the construction works were done in that moment. It's due to the fact that the that co-owner went beyond the delay on purpose, even though the construction was finalized in 2010, 2 years after only the right of ownership was registered in the name of my parents. And in 2017, if I'm not mistaken, my parents went to court with an application in relation to their co-owners in order to delimit the use of that property and to share that real estate that was owned in shares and quotas, to have that property shared in kind and to stop sharing it by quotas. And we have a judgment from court, and which orders for that property to be shared according to the examination report that is attached to the file. Then the defendants challenged this in the court. In 2021, if I'm not mistaken, the judgment of Court of Appeal Chisinau was held, by which the application against the decision of 2018 was issued. Afterwards, already given that I inherited the quota, the share of my father from that property, I went to Public Services Agency in order to register the court judgment from 2018 and to share that, to divide that property into separate real estate properties. But the Public Services Agency rejected my request, saying that cadastral works are needed according to the law on the registration of the real estate. So there is a specific procedure regarding the establishment of real estate properties. Even though I challenged that solution or decision of Public Services Agency in administrative procedure with the court, given that the court of first instance rejected my application, we contracted an agency in this regard. Some cadastral works were done in order to divide that land plot and that property into parts and to register it in the register of properties, and finally this came to an end. So in the register of real estate, we have two properties registered as separate properties, meaning land plot and dwelling, my mother's share and my share, and the other parts owned by the co-owners. But let's come back to the evaluation of the investment. You say that the full amount of investments was worth $10,000. Well, the full amount was $20,000 US. Well, this is the value of the investment, which derives from that agreement and the supporting documents I produced to the Commission. So you claim by that agreement of 2006, ideally, we could see the expenses for building two properties. Well, in that agreement, it is said that our share was to be worth 10,000, and in relation to that value, the value of the investment for the property or part of the property that belonged to my parents, we could estimate it was worth 10,000. I cannot provide specific documents for the entire investment, for the entire building. Well, I suppose that the value of the investment went beyond this amount, but this investment, well, we cannot tell you how high it went, but this investment could not use all the savings of my parents in that period, because I calculated this also. So my parents had in 2006 a sale of a garage from Stăuceni. It is a property that is valuable of a two-story garage, 60 square meters in Stăuceni. In that position, I also attached the certificate from Lara Real Estate Exchange, which shows the price of such a real estate in that period. I also declared in round 2 and 3 of questions that that real estate was sold for 6,500 euros. The Commission did not take this amount into account in the financial flow of my parents for 2006 to till 2017, but they included the value indicated in the contract, which in 2006 indicated the cadastral value of that real estate. But you know that that's not the full amount, and you know that that was the procedure, saying that in the contract we have the cadastral value, but the market value was different. So in the agreement, it was said about 1,500 euros, but it was sold for 6,500 euros. So the value for a land plot, construction plot in a residential area, well, I declared that that property was sold for 27,000 euros. In the contract, we have an amount that goes beyond this, which is the cadastral value of that property. And to support this position, I asked the opinion of Lara Real Estate Exchange in order to find out the market prices for such land plot in that period. And for such a land plot of such a high area, the market prices were estimated from 985,000 till 1 million and more lei for that land plot. So I believe that in that financial flow of my parents, we need to include these amounts and not to refer to the cadastral values that were included in the contract, which were present in this financial flow. So question now, you say that the value of investments probably was higher than $20,000. So we have the value of the agreement and the value of the property that was given into property in 2012. So you say that investments were significantly lower or equal to the value or maybe higher than the indicated value.
Cu siguranță că investițiile nu s-au ridicat la 699.175 lei.
I'm sure that the investments were not about 700,000 lei.
Care a fost efectuat în această construcție.
$2,000 was the major investment in that property. The investments were lower than about 700,000. I admit that additional expenses of $5-7 were involved, but not more. So that's my stance regarding the construction incurred by my parents. These do not reach the amount of 699,175 lei taken into account by the Commission. Could you tell us what was the situation, what was the condition of that property in 2012? Well, I'm not an engineer, I could not tell you about that. But you came up with some images, right? Let me tell you about that. So the pictures that I produced to the Commission in the round 3 of questions represent pictures from the second level of the property that is owned by my mother of the 89 square meters, not the entire construction. It's just the part owned by my mother. So this shows that floor 2 of that building is still empty. It's in a gray version, if that's the right word to put it. And up to this day, my parents did not intend to conduct some repair work at that level, at that story, at that floor of the building. And in that property is occupied by my mother. She needs just the first floor, so we don't need to refurbish the second floor. It was mentioned that those pictures confirm that the works continue up to this day. Well, that's not correct. Those works were conducted in 2016 and 2007. I described the works in conducted in that period. In 2014, well, I could not tell you about the condition of that property in 2012, but I know that my parents did not conducting any works. No investments were done by my parents in that period because they invested massively in that house up to 2007. Maybe later on some insignificant investments were needed, but in 2014 they decided to move to that property and they conducted some repair works. And if you say that they had enough savings, why haven't they continued those works? Later on, I will tell you, because the co-owner was delaying the registration of my parents' property right. That was the reason. For a long time, my parents did not take any action in order to move into that house. What were the reasons for him delaying? Well, maybe those were some personal reasons. I could not express myself on that.
Vă mulțumesc.
Let's hear Laura.
Doamna Busuioc, aș avea și eu câteva întrebări de clarificare privind la aceste aspecte.
Probing questions.
Ne-ați vorbit despre
You
prețul
told us
real
about the real price
care a fost plătit pentru
that
garaj
was
și
paid
pentru
for the
teren,
garage
respectiv
and
6.500
for the
de
land
euro
plot,
și
6,500
de
euro and
Aceste prețuri nu
27,000
sunt
euros.
prețurile din contract.
These are not the prices in the contract. So we have established that. Do you have any document, however,
puteți să faceți referire
or
la alte
can you
indicii care să susțină totuși că aceste
refer
prețuri
to
sunt
other
cele care au
elements
fost
supporting
plătite?
that those were the
Pentru că noi, în
prices
acest
paid
moment,
for these
avem
properties?
un contract.
Because now we have
Și
just
sigur
a
că
contract
suntem
that we
conștienți de
rely
faptul
on,
că uneori
and
valoarea
we
cadastrală
understand
este
that sometimes the
și
cadastral
valoarea
value
reală, dar nici
is not the
nu
same
putem
as
să
the
dăm
real
la o
value,
parte
and the
un
cadastral
contract
value is indicated
și
in
să
the
nu
contract,
înlocuim doar
but we
cu
cannot
simple afirmații.
move
Deci ne
aside the
puteți
contract and
oferi
just to focus
date
on
suplimentare
some
potrivit care să
claims or
ateste
explanations. We need some
aceste
documents that
prețuri?
could certify these prices. Do you have some?
Vă mulțumesc. În susținerea acestei poziții am
Thank you.
anexat
In order to support
la
this
poziția
position,
scrisă
I have
expediată
attached
ieri
to
în
my
adresa Comisiei,
written document and
răspunsurile
position that I
confirmările
submitted
oficiale
the
de
day
la
before
Bursa
yesterday to the
Imobiliară
Commission,
Lara
some
privind prețurile de piață
official
ale
responses
acestor
from
bunuri
Lara
imobile
Property
în
Exchange
perioada
regarding the market
respectivă.
price for
Având în vedere că
those
s-a
properties
scurs
in
o
that
perioadă
period
atât de
in time.
îndelungată
Given that
și s-au
it
schimbat
was
mai mult
some while ago and we have some several co-owners that changed, it was difficult to identify the buyer and to invite them to provide some statements regarding this. But I repeat myself that the land plot in that period was worth
Eu am indicat că părinții mei l-au 65 garajul 6500. Terenul, potrivit prețurilor de piață,
65,000 euros for the land plot.
Eu am indicat că părinții mei l-au vândut
I said that my parents sold it for 27,000. I did not indicate an exaggerated price. This is according to the market prices. And the existing practice in that period that persisted throughout the years on the property, on the real estate market, regarding the cadastral values, those were as prices for the
Și
transaction.
prețurile acestea cum au fost plătite?
How were those prices, was that money paid? In cash, of course.
Și nu există vreo recipisă sau
And
ceva
there is no
pe care să o puteți
notice,
verifica?
no receipt that you could provide to us as a supportive document? Well, unfortunately, I could not indicate or come with other documents given it's been a while now.
Bun, dar totuși aceste tranzacții sunt
however, these
contemporane cu cele
transactions
care privesc
are
terenul și casa despre care am discutat până acum. Aici
regarding the land
invitați să ne
plot
uităm la
and the house. So do
prețurile
you invite
de
us
pe piață
to look
și ne
at the
spuneți că
market
valoarea
prices and
din
to tell
contract nu
us
este
the
cea reală.
value,
partea
the amount
cealaltă
in the contract is not the
susțineți că,
real
de
one. On the
fapt,
other hand,
valoarea
you
indicată în
say
contract
that
este
the
cea reală,
value
cea de
indicated in the
10.000
contract
de
is
euro.
the real one. What do you mean
Că
by that?
ea echivalează cu
Of 10,000.
valoarea totală a
You
cheltuielilor
say
făcute
that
pentru
it
edificarea
is worth or it
acestei
amounts
case,
the
mă rog,
full value of the
înmulțite cu 2 în
expenses
funcție
for
de
that
cei
house,
2.
well, multiplied by 2 because there were two co-owners.
Adică eu încerc să înțeleg totuși cât a costat să se
I'm
ridice
trying to
respectiva
understand how
construcție.
much it
Vă
cost
explic.
to build that
De
construction.
10.000 de dolari aveți în vedere valoarea, este
Da.
cea din contract.
Valoarea ori doi, da?
$10,000
Da, valoarea
multiplied
casei,
by
de
2 is the
locuit,
value of
construite
that
de
entire
0,2.
house.
Da? Această valoare nu a fost indicată în
That value was not
contractul de
indicated
vânzare-cumpărare
in the sales
întocmit la
purchase
notar.
contract concluded
Această
at
valoare
the
a
notary.
fost
That
indicată într-un
amount
acord
was
particular
indicated in a
semnat între
separate
două
agreement
persoane,
signed
un act juridic
between
semnat între
two
două persoane, care nu a
individuals,
fost autentificat
a legal
nicăieri.
contract that was
Este
not
un acord
ratified
între două părți care
by the
o
notary.
parte angajându-se să construiască
It's an agreement by
casă
which
pe terenul altei
one
părți. Și
party
acolo au
agrees
fost
to build
stipulate condițiile
to build a property on the land plot of the other party, and that agreement establishes and notifies the agreement concluded between those two parties. I'm not referring to that contract that was identified at the notary in 2012, because that indicates the amount for 3 properties, not the value of for the construction works invested by my father. Could you tell us once again what happened with that house ending with 01? That house was a historical building. It was in a very poor condition, technically very poor. Part of that house had another co-owner. There was a fire that happened there in 2016, so following that fire, the house was fully destroyed. Appropriate documents were concluded in order to establish its condition, and in 2021, I suppose, the Register of Real Estate registered also its demolition.
Mulțumesc.
I want to clarify. You claim that that house that belonged to 2 co-owners was built in 2006-2007. Meanwhile, the panel has a copy of the handover document dating from 2010. So how do you explain the difference between these years? Let me explain. The owner of that land plot was the other signatory of the agreement. That person had to go to the institutions in order to register the property rights on his land plot in order to be able to hand over the property rights to my parents, according to the agreement in 2006. But he delayed this process. So you say that he delayed the handover of works and the handover of property rights. So basically, you say that he delayed this situation from 2007. So that's the information I have, that the house was built in 2007, involving massive investments. Then no massive investments were needed, but the delay was due to the behavior of this person. What about the other square meters, the other part that belonged to him? That person that delayed the handover of the property, did he or she register the property in his name? Well, he did so because the house was registered in, the land plot was in his name. The house automatically became his possession because he owned the land plot, so he had to hand over the property rights. Did that person have some litigation with your parents, with their father, or some claims? No claim or no litigation existed. which proves once again that the amount invested in the house is the one indicated in that agreement. And we need to look at the prices on the market, because those are not the same as today for the construction work. Given the expenses for the works, for the materials, for maybe the GLs enabling to get the construction materials at an affordable price, for the support of the villagers. That's how we ended up with this cost. In order to conclude this subject, given what you mentioned, we have about $27,000 invested. The amount indicated in the contract in 2012 is about $56,000. So we have a difference of $29,000. So why did you accept to have this amount indicated by $29,000 less? I did not accept. My parents were the signatories in that contract. But I repeat again that the value, the amount, is the amount for 3 properties given to my parents: land plot and 2 constructions. That construction with the cadastral value of 0.1, so had the price according to the cadastral, that was not equal to the investments. The construction had a cadastral value, the land plot had a cadastral value, and the construction that was built by my parents had another cadastral value. The amounts of the quotas, the shares that were given to my parents, were evaluated by the cadastral service at the amount indicated in the contract, and in the contract it is said expressly that this presents the cadastral value according to the certificate issued by the cadastral service. But this again was not the price of the investment, and we cannot see it as the price for the investment. But in the contract, we don't have 3 constructions indicated. Well, the contract mentions 3 properties, 3/8 from the land plot, 3/8 from the dwelling mentioned 0.1, and 2/5 from the house of 178 square meters with the cadastral number 02. And the full amount of these 3 shares amounts to 699,175 lei. So let's go back to the question to clarify, because you explain differently. So you say that this price is only covering the part that it belongs to your parents, but it's 3 properties. It's not 1 property, it's 3 properties. So the quotas, the shares from 3 properties, right? Going back to that flat on H Street, when was it fully renovated? I moved into that apartment by the end of 2020. In 2020. So, the repair work that I had to incur partially for that property were conducted in 2020. The prices that I indicated in the rounds 1, 2, and 3 of questions, and the costs that I had to pay for that property, you can find them there. For refurbishing, for renovating the apartment.
Ulterior, da, eu am mai efectuat anumite lucrări de îmbunătățire în anul 2024.
In 2024, there were some other works conducted. In my declaration of assets and personal interests for 2025, if I'm not mistaken, I have indicated the amount or the investment that I made in that property. So who paid the renovation costs? I paid those. I have declared this in all the rounds of questions. From the income that I had, that was declared accordingly. Who negotiated directly with the construction company? That apartment was identified, was found by my parents. My parents had income after selling another property that I told you earlier. Some details will be mentioned later on. And the purpose was to reinvest those funds and some other savings. And to anticipate the questions of the Commission about whether or not that apartment was meant to be used by me solely and for me to be the sole owner of this apartment, I will tell you the following. My parents bought that apartment as an investment. That apartment is in the proximity of my mother's work, just 5 minutes walk to where she works. So in 2018, my parents, when they decided to invest in that property, they have analyzed the possibility for them living in that apartment. That's why they took the loans that we will discuss later on about, in order to have sufficient funds to start the repair works and later on to decide on what to do with that property. It is possible that, given the prices on the market, maybe that property might have been sold for a higher price, or maybe I also had a probability to own that property. There were several scenarios, but later on my father fell ill, and as of 31st of March 2019, when my father died, we decided that that apartment would belong to me, and after his passing away, I paid the last installments for the apartment, and in 2020, I paid for the refurbishment. Okay, but in 2018, your parents' house on Doina Street was not finalized. It was, but the second floor was not finalized. Well, nobody intended to finalize it, as I told you earlier. They did not intend to finalize it because they didn't need it. So, even though they did not use it, why did they invest such a high amount in the apartment when they just had a house that was not finalized, was not finally refurbished? Well, I think that every person has the right to freely decide what investment to make. So they can freely decide what property deserves to be invested in and what not, does not deserve. Probably my parents were thinking that they would probably not want to live there or live somewhere else, or maybe they thought I probably would have intended to improve my living conditions and move there. So they had several scenarios in their head. Probably they wanted to live in that apartment. They probably thought about that and to move from their house on Doina Street into that apartment. Or maybe they thought I would probably move to that apartment and later on to decide. Maybe one of those properties had to be sold and to get some funds to be later on invested in more attractive properties. Because I, even nowadays, don't think that that house is an attractive property when it comes to the living conditions. So you think that was a poor investment? Well, that's my opinion regarding that property. Maybe it's not now the best time to give details. Let's see if there are other questions regarding the apartment. Only some clarifying questions. You said that it was decided together with your parents that after your father's death, you were to live in that apartment. And after my father's death, I paid the last two installments of the apartment. He passed away on the 1st of July 2019. I paid the installments and then I moved to the apartment 2020. Next aspect, procurement of Mercedes. Yeah. When it comes to the financial flows for 26 to 06 2017, you said earlier, and also you said no, but I also said that the income of from my father's pension was not including financial flow till 2017. So this influences significantly the financial condition and financial flows taken into account by my commission. So there is difference of 545,000 lei, money that was available at the end of 2017, early 2018. I will come with details by the end regarding this aspect, if it's not the right time now. So let's go back to the Mercedes. You said that you bought the Mercedes GLC of 2016 for 19,300 euros from Germany. The panel identified that 5 years later, such vehicles like the one you bought are sold in Germany for on average 25,000 euros. How did it happen that you bought this car for such a low price? In 2021, I wanted to buy another car. So I resorted to not the services, but to the advice of several entities involved in the procurement of cars in order to identify the best price possible for a vehicle, because every person wants to save some money during a transaction. In 2021, I had 55,000 euros only from the sale of the apartment on the street. So 55,000 euros available to me in 2021. Therefore, I could afford to buy a more expensive car, but that car was found by some individuals that go regularly to Germany and back, and they told me that there is a very good offer, very affordable. I have not even seen the announcement for this car. This was recommended to me by individuals that are handling such businesses, that are working with importing cars from Germany to Moldova. I thought this was a very good price, so I decided to buy it. I don't want to comment on how much these cars cost right now or how much those costed earlier. because this price was negotiated by other people, a good friend who's very experienced in that. They know where cars for better prices are sold. They have the skills to identify maybe some defaults, maybe some negative aspects. That's why they were able to get this price for me. So I described these elements throughout the round of questions. Okay. So the person that you empowered to identify a car for you came with other options like also, or just this option? Well, in fact, they provided me several options. I think throughout 2021, we examined several offers. You were looking for a Mercedes or not exactly? Not exactly. So you told them what was the amount that you afforded. I told them maximum 24,000 euros, all fees included. I didn't want to spend all my money for that car. How much did that procedure take till the car was identified with all the cars? The car was identified late September. I was told that there is such a car, and if I wanted to, I could have it brought into Moldova. Given that, we have identified that person, the person that represented me based on the power of attorney. I went to the notary, signed the power of attorney. I gave that person the cash I had, and on the 3rd of October, he brought the car to me in Chisinau. That person, did he give you some other options from other car dealers or just one dealer? Not from the same car dealer. They were different with different options in at different periods in time. Let's say once in 2 months, he could share with me an offer. There is a specific car, and I would say that that car is expensive. I'm not okay with that. I could not remember what were the other dealers, but I suppose they were not the same. I went also to Chisinau, to different car parkings. I was analyzing the possibility of an exchange, maybe. I also had in mind this possibility to change the car for another for a long period. That was 2021 because I had the funds from selling the apartment. How much did that process take? 1 year or more? I think starting with February, I started the search. In 2021, and in October, late September, early October, the car was found, and the price was indeed affordable, so we decided very quickly.
Was the vehicle in a good condition? Yes, it was a normal condition. I am not an expert in cars. For example, I did not see any significant damages. So there are no visible defects. Yes, you're right. So it did not look perfect, but it did not require any significant investments. It was not a new vehicle, it was a second-hand vehicle. I do not know the name of that specific part. It's on the top that you open it. So it was broken, but I did not repair it because I do not need it. And there are some other inner flaws, but they do not affect the possibility to drive the car. In your answers to a round of questions, you submitted a tax invoice for the intermediary that imported the vehicle and also a power of attorney. The customs authorities received the same invoice with the same text and exit number, but on your name. How would you explain this? I received from when he gave me the vehicle, the invoice that I submitted to the commission. He did not give me another invoice. That was the only invoice that I had. But I assume that this seller could issue two invoices with the same number on the name of the actual buyer for customs procedures and on the name of the person that is transporting the vehicle on the EU territory, because he was the one to drive the vehicle on the territory of EU. So if my name was indicated in the invoice, then he could have had problems on the territory of EU. That's what I was explained, because I did not participate in this process. I did not receive any invoice from the seller because I was not present in German. The only invoice that I had was the one that I submitted to the commission, and I am not aware of another invoice with my name. Do you think it's illegal to have two invoices issued for the same vehicle? I cannot tell you anything about this. The invoice was received by the customs service and it was recorded. So we cannot invoke that this is a false invoice, or there are some doubts with regards to authenticity of this invoice. So if we're to make an exercise, and if, for example, in Moldova we have another invoice with the same invoice number, date, do you think these invoices would have been legal? Mr. Iwan, with all respect, I do not make such an exercise. My actions were lawful. I did not violate anything. I did not use several invoices. I did not issue several invoices on different names. When I did this procurement, I acted within the law. I issued a power of attorney for that representative. He traveled to Germany and he gave me the documents that he gave. So the vehicle arrived in the customs and it did not accept the declared value of a bit of and it calculated a new customs. The customs applied the reserve method. There are a number of methods to establish the customs value. According to the explanations included in the annex to notification, the customs requested additional price information, and because they were not submitted, it applied the reserve method to determine the customs value. This is stipulated by the regulation and the relevant law. This does not mean that the customs did not accept the invoice. The invoice was accepted and there is a stamp on it. According to the material submitted to the Commission, on that invoice, there is the seal of the customs confirming that it was received. Establishing the customs value in corroboration with the existing price markets in the Republic of Moldova has regulatory force for the Moldovan market in order to avoid potential measures. My apologies. So this method is a method used in order to regulate the Moldovan market with regards to the imported goods. You also said that you did not participate in the customs clearance process and you did not show up at the customs. The intermediary did this. Yes, you are correct. Did he inform you when he accepted? No, he did not inform me. He did not call me, did not tell me that the customs service established these taxes and this customs value, and depending on the customs value determined the duties. He did not inform me about me, he just told me about the customs duties that were paid. I'm not a professional in this area. I did not think that the fact that the customs service established a certain customs value which was higher and calculated higher duties was problematic. I thought that that was ordinary practice when importing vehicles to the Republic of Moldova. So though the vehicle was bought at a lower price, I believed that usually the customs service establishes the customs value on the basis of market prices in order to calculate higher customs duties. I did not see this as a problem. The customs duties were paid in full, and that's it. So you agreed with the customs value. I was informed post factum when the import duties were already paid. And you did not appeal it. No, I did not believe that it was necessary to appeal it. And I explained why. How were the customs duties paid? They were calculated based on the established customs value. Was it paid by Mr. Yes, at customs, and then you gave him the money? No, I sent to Mr. bigger amount in advance, 23,500 euro. Was it in cash? Yes, you're right. I gave this cash amount so that he has money to pay for the price, to pay the customs duties, because I knew that the customs duties are to be paid when importing into the Republic of Moldova and to cover any other possible expenses. Did he travel with someone else? I don't know. I cannot answer this question. He told me that he brought the vehicle on a special platform. Maybe there were some more vehicles. Maybe he traveled with someone else. I don't know. If you remember the details of the transactions, so you made an advance payment and then they paid the difference. I'll explain to you. I received the answer of the seller and I sent it after receiving the annex to the notification, because that was a doubt in the opinion of the Commission. I mean, the price for this vehicle. I contacted the buyer, SV Automobile, which informed me that Mr. Tofan inspected the vehicle on September 24th, 2021 and paid 10,000 euro on that date. After that, he took over the vehicle in September 2021 and he paid then 9,300 euro. I did not send him the money in installments. I assumed that maybe he was in Germany. He showed me the vehicle. I liked it. He paid maybe using his own money. And after that, I issued him the power of attorney and paid the lump sum, the whole amount. I did not give him the money in installments. The seller, according to the answer that I received and I attached, confirmed this price of 19,300 euro, showing that 10,000 were paid on September 24th and 9,300 on September the 30th, when the vehicle was handed in. So, if this seller can issue two invoices on different names with the same number and the same data, exactly the same, only the names different, do you admit that he might issue an invoice showing an unreal price? Please do not smile, just explain. I think the situation is very interesting. How is it possible in 5 years a vehicle to be now on the market more expensive than 5 years ago? We do not ask these questions only for the sake of asking them. But that's a question that anyone who would like to have trust in the prosecution system, in our work, how can we explain that in 5 years the cost of a vehicle or the price of a vehicle is higher on the same market, the German market, compared to what you have procured, and you say that you paid this price. Now the vehicle is not more expensive in Germany. There are prices of 19,000 that the Commission itself attached to the evaluation procedure. So the prices for this vehicle are different, not only 22,000. That's the idea of bringing a vehicle from abroad in order to make some savings. So the idea is to find a convenient offer. It is not for the first time when a cheaper vehicle is brought from abroad. It's not me, the first person to do this, to bring a vehicle from abroad that has prices lower than prices in Moldova and prices in Germany. So there are different offers and different price gaps. So I cannot speak on behalf of the seller who issued one or two invoices. I have not issued those invoices. What I've said with regards to two power of attorneys was only an assumption of mine. It was not a fact. I did not say that this happened for sure. I did not state that the seller did something that is in non-compliance with certain rules or norms. So I reiterate that it is not for the first time when a vehicle is identified, negotiated and brought from Germany to Moldova at prices that are much lower than the market price. And I do not believe that this should raise any integrity-related questions about myself. I reiterate, I had enough money to buy a more expensive vehicle, but I found this offer and I brought a cheaper vehicle because the offer was very convenient. Why the seller sold this vehicle at prices that were lower than the market prices, I do not know. But perhaps he had certain reasons why to sell this vehicle at a lower price, because the vehicle was not and still is not in ideal condition. Mrs. Busuioc, did you know this intermediary? Because I believe that you trusted him a lot to give this amount in cash. This person, my representative, was recommended by people that I know very well, and I trusted those people. I trusted that they would not recommend a person that would lie or steal the money or not bring the vehicle that was ordered by me or accepted by me. Can you please clarify how much money did you give to him in cash? I gave him 23,500 euro. And what was the final price of the vehicle? It costed 23,300 euro, including customs duties and the transportation services. So I have also to clarify the financial flows for 2020, why this amount of 500 euro were paid for transportation. So this amount was included in the price of the vehicle and deducted from the income that I received from selling the apartment. But my flows were this amount was deducted from my salary amount. So this has to be corrected. So 23,300, that was the price of the vehicle, and this price included also the transportation to the Republic of Moldova. And when you gave him this cash amount, did you sign a certain paper or you just trusted him? I trusted the intermediary because he was recommended by people that I know very well, and I did not have any doubts that he would fulfill the assumed commitments, that he would live up to our agreements. And in the customs document that was submitted to you, I assume that he gave you the customs documents when giving you the vehicle. You are a prosecutor. You have experience in reviewing such documents. Don't you believe that this statement that the customs service made, that they do not believe that the value of the vehicle in the receipt is accurate and applies the alternative method to determine the customs value was a weakness. No, there is no such statement in the customs documents. In the customs documents, there is only a statement that the customs service established the customs value of 25,300, I believe. That's the only statement made. The reason is not included there. But in the materials of the evaluation procedure, when the Commission asked the customs service, I saw that the customs service explained why they determined this customs amount of 25,300, explaining that this is a reserve method that is used when the customs service cannot determine for sure the price of transaction. But I would like to reiterate that all of the documents that were filled in by my representative in customs, he included everywhere the price of 19,300 euro in the customs statement and other documents prepared there in the customs service. The fact that he did not have any other documents to confirm the price, only that invoice, I believe that was the reason why the customs service decided to use the reserve method. The fact that he did not have any other documents to confirm 19,300, well, what other documents he could have had? Well, he did not have any other documents. The seller gave him only the invoice. There was no other documents to confirm the price. So he submitted to the customs office only what he had. But maybe you made some calculations. Maybe you realized that the duties were not calculated on the basis of the invoice amount, but at a higher amount. I was explained that this is a frequent practice, that the customs service, when importing vehicles, uses the price market to determine the customs value, irrespective of the price indicated in the invoice. That's what I was explained, and that's why I did not have any doubts. And that's why actually I am surprised now that there are so many doubts regarding my behavior with regards to the transactions around this vehicle. Now, we are trying to explain certain situations. We have to admit that this is quite a peculiar situation to see two identical invoices but on different names. We try to clarify this. That's why we ask you these questions. Thank you very much. I do not have any other questions. So let's continue with the next aspect. The panel asked in question 23 in round 2 to estimate the health costs. So I would like to continue with the financial flows for 2021 with this amount of 500 euro. I would like to explain the situation better. The amount of 500 euro was included in the financial flows for 2021 separately, representing transportation costs for the import of this vehicle. But I reiterate that this amount was included in the overall cost of the vehicle, 23,300, stated in the wealth statement declaration for 2021. The price of vehicle consists of 19,300, which is the actual vehicle price, 3,350 that were converted in Moldovan lei, and this makes 22,850 lei. So this amount, 22,850 euro, after converting 350, we had 71,000 over lei, of which, from which the customs duties were paid. So we have a difference of about 1,200 lei from 71,495 and the other amount. So it's 1,208 lei, so 400 euro. And these 1,208 lei were kept for the transportation costs, and I was reimbursed only 200 euro. So I showed the price of vehicle 23,300 euro, which includes the transportation cost of 500 euro. And in the next year, in the declaration for 2021, I indicated a cash balance of 31,700, removing this investment in vehicle. So the source for paying this amount of 500 euro was the income obtained from the sales of apartment. It's not the current financial flow for 2021. So that's what I wanted to explain. Okay, thank you. The next question. In question 23, round 2, you were asked to estimate the healthcare costs, and you said that this was made through your bank account, and you did not have any significant healthcare payments in cash. But we found in 2021 an amount of 41,850 lei for in cash for health costs, and also another amount of 21,000. So in my 5-year declaration, I showed an expense for healthcare costs in 2023, but that's not this one that is indicated in 2021. That's another medical costs. I can provide the following explanation. I did not have the intention to hide any services paid on my name for this period. I declared the medical costs, the services that I received in 2023. In 2021, the Commission identified a payment of about 41,850 lei. That was a single amount, and that was to be declared by me. I did not omit its declaration intentionally because I did not make this payment. I'll explain why. During that period, indeed, I had some health issues, and my mother was a doctor, and she came with me to all consultations and all medical investigations that I received during that period. She discussed with the doctors, and she coordinated my treatment during that period and all of the procedures that were conducted. And she contributed to the payment of the price for these medical procedures. I reiterate that I had enough money to cover these costs, but that was the initiative of my mother to help me somehow during that period that was more complicated for me because of the health issues. So it was my mother to pay for these services during that period in 2021. So I had a number of services in Sancos, Nova Med, and perhaps some expenses at the laboratory that was identified by the Commission. I was not aware about this single-off payment. Were there any other expenses that were somehow omitted, or it was only these other health-related expenses? I don't know. I did not keep records of all payments that I made for healthcare services. There are many expenses or many payments that were made using bank card, and they are visible. The other expenses, I did not record them, and I did not have the intention to hide certain payments, especially for medical services. The next question. In the notification, the panel has doubts with regards to the small costs for travels. For example, for vacations from 4 to 8 days in various locations. You had from 2,000 up to 5,000 lei in Vienna, St. Petersburg, and other well-known places. So, to give you an example, in Venice, I would travel there frequently because in Nestre, which is a town located close to Venice, the mother of my friend, so she lives there. So my friend travels there during the summer times and winter times for vacations. So I join her for shorter periods of time, for about 1 week. I live in their flat. I eat also with them, and because I am a guest and a close friend of their family, they do not give me an invoice for the food I eat together with them. So I have only current expenses when we go out, and these expenses can be seen on my in my transactions by card. I've indicated the transportation costs when assessing the cost of travel. So I included the estimate cost for travels. What about Rome and other destinations? So for Rome and Barcelona, I indicated a higher amount, considering also the accommodation and transportation costs. Because in Rome and Barcelona, there I indicated a price that is compatible with travel costs. So I included there transportation and hotel. So during all of the visits, when you stay at your close friends, don't you invite them for a dinner out? Don't you take any presents for them? Don't you have such expenses? Well, I ask you based on my own experience. When I live with someone, oftentimes I have even bigger expenses compared to what I would have paid if renting a B&B apartment. I do not take any presents for them. Maybe once in 2014, when I was there for the first time. I don't remember if I had some presents back then. But it was a symbolic present. They are very close friends. It was not a very expensive present that would generate huge expenses for me and might somehow impact my financial condition. Yes, we could have eat out, but if we have a pizza, what would be the price of pizza compared to the expenses that the Commission can appreciate based on my financial flows? So to eat once a week a pizza, I believe these amounts can be included in the amounts estimated by me for these travels. And also you can see the payments that I made using my card in restaurants or in other locations abroad. Thank you. Now we will close the meeting to discuss issues related to third parties that have a contribution to certain assets. Just a minute. So we return to public hearing. Mrs. Busuioc, the last issue that we would like to discuss is the sales of Mercedes to a judge. In October 2021, you sold the Mercedes E2020 in 2010 to a third party that seems that has not used the vehicle and then sold it to Judge Sandu. Judge Sandu stated in the pre-vetting process that he was aware of your intention to sell this vehicle. The judge bought this vehicle in November 2020. At the same time, the panel identified a series of cases previously and after the transaction when you did not declare a potential conflict of interest. Could you please explain? Do you believe that a prosecutor should have notified the parties to a process about the transactions that they had in the past with the judge presiding the case? I disagree with the conclusion of the panel, according to which the sales transaction of Mercedes, year of manufacture 2010, would generate doubts with regards to my compliance with the ethical integrity standards. This conclusion is based exclusively on circumstances that took place after the sale of the vehicle, which I was unaware of and which I could not influence, which I could not change. On October the 6th, 2021, I sold the vehicle to Mr. C on the basis of a sales agreement that was concluded with him. Mr. C and myself would not have any personal, professional, patrimonial or other type of relations. And after selling the ownership rights, we did not have any other relations with Mr. C. I was not aware and I could not know that Mr. C was a friend of judge mentioned by you, and that he wanted to sell later the vehicle. These circumstances became aware to me only during the external evaluation of the judge, and this happened a couple of years later. So in these conditions, I did not have any legal grounds that obliged me to formulate a recusal statement or declare conflicts of interest. According to Article 33, incompatibility of the prosecutor can be asserted only if there are some expressly stipulated circumstances, such as personal interest, kinship relations, participation in the same case, or other circumstances that cast a shadow of doubt over these circumstances. I did not have any of such circumstances. The conflict of interest is defined by Law 133 as a situation when the person is called to adopt a decision on a matter where he or she has a personal interest or that relates close people or people that he or she has patrimonial relations. And this interest impacts or can impact the impartial or objective fulfillment of the assignment. I did not have any personal, patrimonial or other type of interest with regards to Judge Victor Sandu. So there is no conflict of law within the meaning of the law. The cases are assigned according to the institutional mechanism stipulated by the law, and the prosecutor cannot influence and cannot choose the judge that will try the case. So I fulfilled my duties as a prosecutor, and when the case was assigned to the judge, I was not aware that he became the owner of the vehicle. So without having this information, I could not appreciate the existence of a conflict of interests or any grounds for recusal. I can continue and express my opinion with regards to the violation of the ethic codes that are stipulated in the annex to the hearing notification. They are described in line with each norm of the code, and my specific actions by proving that none of the action that I have carried out could be interpreted as a violation of any item of the prosecutor's code of ethics. I will not read it. I don't think it's the case. Thank you very much, Mrs. Busuioc. You remember the circumstances when you sold this vehicle? How did you find the buyer?
Eu nu am identificat
I
cumpărătorul.
have not found the buyer.
După cum v-am zis,
As
eu
I
eram
told
în
you,
căutarea
I was looking for another vehicle and I wanted to change my vehicle since early 2021. I visited a number of parking places. I left them my phone numbers. I analyzed various exchange opportunities,
care, de fapt, nu mi-au
which actually
aranjat,
I did not like them.
determinat că nu au fost efectuate
So
singure
because of
tranzacții.
that, I did not exchange my vehicle for another one. I left my phone numbers with those parking places. So
Recomandat automobilul
the people who recommended the vehicle that I bought in October 2021,
de model
Mercedes
GLC,
GLC,
cunoșteau că eu
knew that I wanted to sell my
anul fabricației
Mercedes manufactured year of 2010 because I wanted to buy a new one.
Domnul în cauză, domnul C,
Mr. C called me
spunându-mi
and told me
cunoaște că eu
that
vreau să-mi vând automobil.
he knew about my intention to sell my vehicle.
Cunoscând despre faptul că
So
multiple persoane cunosc că eu doresc să vând automobil.
So considering the fact that so many people knew about my intention that I want to sell my vehicle, I did not ask him how he got that information. I said, yes, I am selling my vehicle. That's all. So he came, he saw the vehicle, he liked it.
Prețul era unul
The
real,
price
nici
was
exagerat,
realistic. It was neither too high nor too low,
care l-am solicitat.
the price that I asked for the vehicle. So you say that Mr. Sandu did not put you into contact with this buyer. Mr. Sandu did not put me into contact with this buyer. I declared that with my full responsibility. I did not have any discussions with Mr. Sandu about this vehicle and about the fact that I wanted to sell it to Mr. C. I believe that this is the message that the Commission is trying to convey via this question. So this derives from the decision of the Supreme Court of Justice and the findings found when assessing Judge Sandu in pre-vetting. You received the decision of the Supreme Court of Justice, you read it. I do not ask you anything else that is not proved by a legal document.
Decizia Curții Supreme de Justiție nu este stipulat
Yes, but the CSJ
că eu am negociat cu domnul.
decision does not stipulate that I negotiated with Mr. Sandu or other circumstances of those negotiations.
Curții Supreme, de asemenea, sunt expuse niște
The decision of the Supreme Court of
referitor la cronologia evenimentelor procurării
Justice
acestui automobil.
includes only some assumptions with regards to the flow of events related to the procurement of this vehicle. And these fostered some assumptions that this would be a successful transaction. The Supreme Court of Justice decision does not stipulate that it was me who suggested to Victor Sandu to buy the vehicle, or Mr. Sandu contacted me with the intention to buy my vehicle. There is no such finding there. Thank you. We have the decision. Do you have any other questions? No. Okay. So, if you want, you can make your final statement. It's not compulsory. It's if you want to. If not, we will close the meeting.
Aș dori la final
Yes, I want
să mă expun
to
generale.
make a general statement with regards to all of the doubts that were listed by the Commission in the annex to hearing notification, and I want to express my disagreement with the preliminary findings of the Commission. I want to reiterate that the negative balances estimated by the Commission for 2012, 2013, 2014 attributed to financial flows are the results of overstated consumption expenses, especially the costs of foodstuff and public utilities, because during that period I lived with my parents in the same household, and the foodstuff for the whole family and the public utilities were paid by my parents, because they were the people who managed the household and covered those costs. I disagree with the calculations made by the Commission and understatement of the income of my parents. I reviewed the calculations. I included all lawful incomes of my parents, so we have positive balance of about 100,000 lei for each year in the period between 2012 to 2014, which shows that the parents had enough funds to be able to cover the expenses that I mentioned earlier. I disagree with the statements made by the Commission that the parents of the subject were not able to provide financial support to the daughter. This is shown by the calculations that I presented and described in details. At the same time, I deny the statement of the panel according to which the construction works and repair works at the real estate on Doina Street continued so far, so they started in 2016 and still continue. The fact that the second floor was not finished, it is not used as a dwelling space, so this does not prove that we invested on a continuous basis in this real estate. Actually, it proves that no investments were made. The fact that the second level remained unfinished proves that my parents did not invest any funds and that these investments did not continue over years. I declared throughout the whole procedure that these works were finished in 2007 and the repair works were conducted in 2014. The Commission's analysis of the unexplained wealth for 2018 also is based on a series of fundamentally wrong preconditions that impacted the conclusions with regards to the financial condition of my parents. The Commission misinterpreted the cadastral value of 699,175 lei of the real estate as an investment made by my parents in building the house. Also, the Commission did not include the revenue obtained by my parents from the sales of real estate, including the amount collected by my mother from selling an apartment, though this transaction and the actual price were proved by some written notes and declarations made by people during the evaluation process. The Commission did not take into account the loans given by people, though the financial capacity of these creditors was proved by their statements and by their financial and banking documents that were attached. The Commission's review also did not reflect fully the income of my parents from salaries, pensions, and social allowances in the period 2016 and 2017, and their capacity to make savings throughout the years. So by accumulating these errors of assessing the financial capacity of my parents, resulted in wrong conclusions that my parents could not make the savings that they had at the beginning of 2018, and they did not have the possibility to pay the first 3 installments for the apartments. But all of the written statements and explanations submitted during the evaluation process proves the contrary. Therefore, I kindly ask the Commission to review the financial flows and to base it on the actual economic transactions and the evidence submitted, to include the revenue obtained from the sales of garage and land, to remove the amount of 699,175 as alleged investments, and to use the amount of about $20,000 as investment in constructions, as proved by the agreement of 2016 and the justification documents. Another significant gap that impacted significantly the financial flows of my parents is the fact that the Commission did not include the allowance for work victims collected by my father, which is about 1,402,779.15 lei, but not 87,649 as indicated by the Commission in the table. Having said that, I believe that the negative balance attributed to my household for 2018 should be removed because it is based exclusively by the wrong assignment, the amount, the alleged payment for the procurement of the apartment on H Street, because these costs were covered by my parents. Because of Commission's failure to take into account the revenue and savings made by my parents. So the negative balance assigned to me for 2019 is also based exclusively on the fact that the Commission assigned fully to my household the payment of the third installment for the apartment. So if this is removed, the balance for 2019 becomes positive. Regarding Mercedes GLC 295D, my position stays the same. The procurement price is 19,300 euro. This is not based only by my explanations, but also we have evidence, the invoice from September the 30th, the power of attorney issued to the representative statements on the circumstances of the transaction, and import-related documents, and the direct confirmation issued by the selling company. Regarding the two invoices, and where the difference is only the name, not the price of transaction. Therefore, both invoices indicate the same vehicle, the same date, the same price, 19,300 euro. Hence, in order to remove these doubts, I requested SIA Automobili company to confirm the price. The seller confirmed that actual price of the vehicle was 19,300 euro and that the amount was paid in cash by my representative. This confirmation is corroborated with the invoice of September the 30th and the declaration of the respective person. The value of 25,300 euro established by the customs service is not the actual price paid to the seller. The customs service did not say that the invoice was false and that I paid 25,300. This amount was determined by applying the reserve methods to determine the customs value. That's why we have to differentiate between the contract price of 19,300 and the customs value of 25,300. So considering this, I believe that the amount of 25,300 should be removed from my flows, my financial flows, and it has to be replaced with 19,300, which is the actual amount paid to the seller. Regarding the amount of 500 euro, the equivalent of a bit over 10,000 lei, I believe that I have explained clearly that it has to be removed from my financial flows in order to avoid double counting, because the source of payment was the revenue from the sales of apartment, which was confirmed by the decrease of declared cash in my assets declaration for 2021 with regards to the healthcare services that I received in 2021. I have submitted additionally the declaration of my mother, who confirmed that she paid for those medical expenses because she was the one to accompany me and she coordinated my treatment during that period. There was no intention to hide one-off amount that was above the selling, because I was not aware that such a payment was made. And if we remove these financial flows, these payments from the financial flows, and we replace them, we replace the price stated by the Commission for the procurement of the vehicle with the actual price paid, and if we remove 500 euro as a separate payment, the balance for 2021 becomes positive 42,321 lei. Regarding the sales of Mercedes E 2020, I disagree with the conclusion of the panel that this transaction generates doubts with regards to my compliance with ethical integrity standards. This conclusion is built retrospectively based on some circumstances which occurred after the sales of the vehicle, circumstances that I was not aware of when selling the vehicle. I want to make a clarification. The President referred to the decision of the Supreme Court of Justice. The decision of the Supreme Court of Justice, as you have mentioned yourself, stipulates that Mr. Victor Sandu was aware that I am selling the vehicle. I want to clarify. I don't know how Victor Sandu was aware of the fact that I am selling the vehicle, but I did not tell this to the judge. How he found out that I am selling the vehicle has to be analyzed based on the materials that are part of the assessment of the judge. I did not have any discussions with the judge in September or October 2021, not even later. I found out about this fact when he went through his pre-vetting procedure. So only then I found out that he bought the vehicle sold by me. I was not aware of these circumstances, and I reiterate, the Supreme Court of Justice decision does not stipulate that I negotiated with the judge. It stipulates only that the judge was aware. How he found out about this, it is to be established. Mrs. Busuioc, I did not want to go into details, but if you insist, the judge mentioned and explained this in front of the Supreme Court of Justice, that he overheard a phone discussion that you had, that you wanted to sell your vehicle. So he sent this information to Mr. Crudo. So you totally deny this. The judge overheard a discussion that I wanted to sell the vehicle. He did not hear it from me. He did not hear it from me. I reiterate this fact. The judge overheard a phone discussion that you had while he was around you. He just heard you He did not talk to you at all. He did not ask you what type of vehicle, whether you want to sell it or not. He just overheard this information and told Mr. Crudo about this. And he gave Mr. Crudo your phone number. Yes, I guess this is how it happened, because I did not have any discussion with the judge on this matter. The fact that he overheard a phone discussion is not the same like me telling him that I want to sell the vehicle and to invite him to see it or inspect it or buy it. So you have never heard this vehicle in the yard of the court or around the court building. So after the transaction, you have noticed that vehicle parked near the court building. No, I do not see the vehicles of judges. I don't know where they are parked, because it was your vehicle. You should have known it. No, I have not seen it. I tell you for sure, and very frank, I have not seen the vehicle of Judge Sandu. I don't know where judges park their vehicles. And for sure, if you go to Chocana Court building, you will see that the judges do not park their cars in front of the building.
Thank you for your today's presence. Thank you for all your answers. Thank you from my side. Well, to continue my idea about the lack of some doubts regarding my ethical integrity when it comes to this situation related to the car later on bought by the judge, I want to repeat that pursuant to Article 3, Item 3 and 4 from the Code of Ethics of the Judges, there were no relations or financial, social, family gains that would influence the professional behavior after buying that car by that person. Mr. C had no pecuniary interest in regards to that car, and the relationship between Mr. C and the judge and resales of that car was not known to me. It cannot be claimed that I allowed a relationship to affect my professional activity when that relationship did not exist in relation to myself, and I was not even aware of it. This is also relevant pursuant to Article 11, Item 2 in the Law 252 of 2022, which regulates ethical integrity and serious misconduct or leading to incompatibilities and conflicts of interests affecting the professional activities. In my situation, there is no specific action which shows that I benefited the judge in terms of when it comes to the car or some where that affected my attributions. The Commission evaluates my conduct based on some information that I found out years later, or saying that those might have affected my impartiality in conditions that supposedly I had to be aware and in relation to which I could have taken a specific action. Given that we don't have that, we might end up with some obligation that is impossible to be executed. The one to declare or avoid grounded conflict that is grounded on elements known to me. To conclude, I kindly ask all the evidence information that was presented to me throughout the discovery procedure to be analyzed as a whole by abiding the evidentiary standards in the Law 252. I appreciate and claim that the procedure cannot be based on suppositions, probabilities, or assumptions, but only on proven facts and on a corroborated appreciation of the evidence in line with the standards developed by the case law of the ECHR, which look at the justification of decisions. I am persuaded that a complex, unbiased analysis will lead to the conclusion that my explanations are consistent, reliable, and supported by the evidence handled, and the requirements when it comes to integrity, financial and ethical, are fully abided by in the Law 252. To conclude, I want to thank you for the possibility to present my point of view. I rely on the professionalism of the panel, and I'm confident that all the evidence will be examined as a whole. Thank you. We want to thank you from our side. I declare this hearing closed. Thank you.